ಹಲೋ 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 ಹಲೋ
ಸರ್
ಸರ್ ಮೆನ್ಷನ್ ಮಾಡ್ಬೋದಾ?
ಇಲ್ಲ ಸರ್, ಮ್ಯಾಟರ್ ರೀಚ್ ಆದ ಕೇಳ್ಬೇಕು ಸರ್, ಮುಂಚೆನೆ ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ. 10:30 ಬೈತಾರ ಸಾಹೇಬ್ರು.
ಹೌದಾ? ಅದಕ್ಕನ್ನ ತಮ್ಮನ್ ಕೇಳೋಣ ಅಂತಂದು ಇದು ಮಾಡಿದ್ವಿ ಸರ್. ಹಲೋ
ಆಯ್ತು, ಹೇಳಿದ್ನಲ್ಲ ಹೇಳಿದ್ನಲ್ಲ ಕೇಳ್ಬೇಡಿ ಅಂತ.
ಅದ ರೀಚ್ ಆದಾಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾ?
ಹೌದು ಸರ್.
ನಾ ಮೆನ್ಷನ್ ಮಾಡೋಣ ಅಂತಂದಿದ್ದೆ, ಅದಕ್ಕೆ ಕೇಳೋಣ ಅಂತ ತಮ್ಮನ್ ಫೋನ್ ಮಾಡಿದೆ. ಹಲೋ
ಹೇಳಿ ಸರ್.
ಹಂಗಾರೆ ಮೆನ್ಷನ್ ಮಾಡೋದು ಅಲ್ಲ, ಮೆನ್ಷನ್ ಮಾಡೋದು ಬೇಡೇನ್ ಸರ್?
ಬೇಡ ಸರ್, ಹೇಳಿದ್ದೇನೆ ತಿರ್ಗಾ ಮುರ್ಗಾ ಕೇಳ್ತಿರಲ್ಲ. ಮ್ಯಾಟರ್ ರೀಚ್ ಆದ ಕೇಳಿ, ಮ್ಯಾಟರ್ ರೀಚ್ ಆದ ಕೇಳಿ.
ಸರಿ ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ನಮ್ದು ಮಾತ್ರ ಬರ್ತದೆ. ವೈದ್ಯಕೀಯ ಸ್ಯಾಲರಿ ಬರ್ತಿದೆ ಕೇಸ್ ಅಟೆಂಡ್ ಮಾಡಿ ಹೈಕೋರ್ಟಲ್ಲಿ
awaited. Available warrant for this. Report is still available.
Yes, Mr.
This was my last. Counsel on record has expired. Notice is sufficient to appellant.
So notice on respondent held to be sir. Appellate.
Yes.
No, none appears. Right service of notice, none appear on behalf of the appellant. Appears. Not interested.
He's asking for time.
Why?
Asking later. Next.
Hey, Michael, we didn't expect that we will need so early in the morning. Counsel for appellant did not yet expired, so therefore we had issued notice to him. Notice has been served. Despite that, none appears for appellant. We have dismissed it for want of prosecution. He wants a week's time for what? We don't know. Tell him. Understood, right? Amicus is so good that he makes everyone understand.
I am respond 2, 4 and 6, my lord. Respond 2, 4 to 6, my lord.
Yes, please.
My lords, I filed an affidavit along with the amount has been paid. So far as
Not served?
amount, no salary is due, my lord, as on today, my lordship.
No, but you need to serve a copy of whatever you have filed. on
That
the
was
other
filed,
side.
the same was served and was filed, my lordship. It was served. The matter has to be heard, my lordship.
Email through it is, sir.
Through
Through
email.
email.
Yes.
How do you say Mr. so casually? Like,
And after that, the party has come before the
Wait,
court,
wait.
my lords.
instant. Oh, Mr. Let the appeal be listed for orders on admission in the next week.
Please.
Weeks. Preempted.
Right? Siddaramaiah. Vandana PA.
Retirement. has So and so. Accepted. This is directed to delete the name of Mr. Harish Bhandari. What is it, Mr.? Item 5.5. Dissolution of marriage. Appeal is admitted for hearing. Record. Weeks. Complying with office of. Weeks time. Comply with office. Weeks preemptory.
Number 9. Vijay Prakash here. All is okay. Sir.
Child custody. State counsel for respondent number 4 submits that statement of objection shall be filed during the course of the day. When do you want? Yes, in the next week.
Okay. Prasanna here. Government advocate.
not be way to know about whereabouts. So habeas corpus is not a means. You will have to make some efforts at your level, right? This is not, yes.
You will file a memo, sir. CG.
Huh?
Whatever you have stated, you will file a memo.
Recorded. What is the meaning? Mark the presence. After hearing learned counsel for the petitioner, office objection is ignored. This petition has been filed seeking a writ of habeas corpus for production of Miss Cyril Mumita Mark, who is aged about 19 years. Paragraph. The petitioner claims to be grandmother of the aforesaid Miss Cyril. It is stated in the petition that her granddaughter is missing. Paragraph. In response, the High Court government leader has invited the attention of this court to averments made in the petition itself and has pointed out that pursuant to the complaint lodged by the petitioner, crime number 125/2021 has been registered as the granddaughter of the petitioner was missing. It is further submitted that during the course of the investigation, the granddaughter of the petitioner was found in Tirupati and 22/1/2023 and the petitioner has been apprised that our granddaughter has married one Mr. Bharat. Full stop. Therefore, line below. Therefore, it is submitted that crime number 125/2022 has been closed. Paragraph. Closure report has been submitted. It is submitted that therefore it is submitted that closure report has been submitted by the police to the jurisdiction. Paragraph. The aforesaid submission is placed on record in view of aforesaid submission. Nothing survives for adjudication in this petition. However, needless to state that petitioner shall be at liberty to take recourse to such remedy as may be available to her in law with regard to her grievance, if any. The aforesaid liberty petition is disposed. On impleadment, that application, if any, on behalf for impleadment of National Medical Council be filed within a week. This thereafter. Bharat Kumar Party. Yes. Current count. Failing which appropriate order shall be passed. Yet said. Current counsel for the appellant undertakes to file objections on or before Thursday's voting on or before 2nd of March 2023. It is made clear that in case no objections are filed, appropriate orders on IA 2 of 22 shall be passed on 2nd March. Sadashivappa. Minutes. Sharat Kumar, Ordered on IA 1 of 22, taking into account the appeal is pending since 2018, as well as the nature of controversy involved in the appeal, IA is allowed. Let the same be listed for final hearing on 28th March. 28th March 23. What have you done if arrears of maintenance has not been paid? Nothing. Madam, can we take notice of these facts on the basis of oral submissions? Please file. Please file an application seeking appropriate direction. Oral, he is not put to notice. You are listed for hearing, and in that case, you are submitting that maintenance from what period, which is the order. File an application, do something. Admitted for hearing.
Maintenance application will not.
Appeal is admitted for hearing. The beginning you write, but on IA 1. 15, in Prasad. Rapinawad. On IA 1 of. Then aside duly net notice be published for appearance of respondent number 5 before this court in Delhi.
New Indian Express for Canada and
Which edition?
Bangalore.
Bangalore edition for appearance of respondent number 5 before this court on 4th April 23. Accordingly, IA 1 of 22 is allowed. Dispensation right 1 of 21 is also allowed. Like requirement of file production of color photograph is dispensed. Petition number 60. Narayan Bhai. What happened to that writ appeal? Bombay High Court. Yes, it has to be. Right. We will remand the matter. Why? We have read it, Mr. You may not have read the case, but we have done our homework. What compliance? Yes, Mr. How this can be done? So all cases, I mean, then it's very easy for us. All cases, we should ask the council to find out which High Court. Supposing if it says Kerala High Court, we will say simply it will be abide by the decision which may be taken by Kerala High Court. Right? Can it be done? Can't be done. All right. This intra-court appeal. What is there to seek adjournment? You have simply said the learned single judge has not decided my petition on merits and has said that it will be governed by decision which may be taken by Bombay High Court. Simple, right? For this, it is pending since 6 years now, 2017 till 6 years. You have not even said it today also. We are saying. This intra-court appeal has been filed against an order dated 9th of March 2017, passed by the learned single judge, by which writ petition preferred by the appellate has been disposed of with the direction that the case of the appellant shall be regulated in terms of the final outcome of 1858/2003 on the file of High Court of Judicature at Bombay, paragraph. We have heard learned counsel for the parties at length, comma, in our considered opinion, comma, taking into account the averments made in the petition, comma, the learned single judge ought to have dealt with the matter on merits instead of directing that disposal of the writ petition filed by the appellant shall be governed by disposal of writ petition in WP number 1858 part 2003 paragraph. There, line below, therefore, the impugned order dated 9th of March 2017 is set aside. Learned single judge is requested to adjudicate the controversy involved in the writ petition on merits. Line below, accordingly. Correct. Huh? Huh? Yes. Land has been acquired. How can it be? We have information. No, nothing. No inconvenience, no problem. The case is decided. Inconvenience automatically will disappear, right? Why face inconvenience? We are recording our statement. That's the ground. Simple thing. What is the point? Why your petition has been dismissed? Tell us. Now, why it has been dismissed? Oh, that the land in question in respect of which you are seeking regularization is subject matter of acquisition. Now, learning says that it has been acquired. Subject matter of litigation before, all right. Yes. So, madam, what happened to this WA 437? No throat infection. Just now, Saturday, Sunday. 437.
This is connected.
What? So we will hear 437 first. Huh? Without admission. We are yet to decide whether the case is fit for admission. You are saying posted for final year. Why? What have you done? You are wearing the mask. There is no throat infection. So please argue. But there is no throat infection. You are not suffering. Your throat is all right. Please argue. You are a counsel. We will. No. You are not an irregular counsel. There is nothing. Advocates Act does not recognize any irregular counsel. You are not an irregular counsel. Who told you? We will recommend you in the next full court meeting for designation as senior counsel. Please argue. Then nothing. Don't argue. We will decide it. It's our job to decide it. We will decide it. Don't argue. We will say that you are not willing to argue. He doesn't want to argue. We will peruse the record and decide. Good time. Why throat infection? Why this thing? Better.
It's connected appeal. It's first time acquisition of past, again second time they have cured all the defects and completed the acquisition. Typically, they just dismiss the report. So he's regular.
No wasted right in there.
Yes. For him, there is no right even for
All
this
right.
also.
Yes. Right. Forget about it. Forget. This intra-court appeal has been filed against an order dated 6th of December 2016, passed by learned single judge, by which writ petition preferred by the appellant has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellants were in unauthorized occupation of the land in question. The appellant submitted an application to Mysore Development Authority seeking regularization of the land in question, land which was in their unauthorized occupation. The aforesaid application was rejected by the Mysore Development Authority by an order dated 15/10/2014. The appellant challenged the aforesaid endorsement in a writ petition, namely WP number 51523-51 writ petitions, right? Writ petitions, namely WP number 51523-51662/2015. The learned single judge by an order dated so and so 6th of December 2016 has dismissed the writ petition. Paragraph. We have heard learned counsel for the parties at length. From perusal of the order, it is order passed by the learned single judge. It is evident that the land in respect of which the appellants are seeking regularization is subject matter of acquisition proceedings, which is pending before a division bench of this court, namely WA number 437/2014. The learned single judge therefore has concluded that since the subject matter of the land in respect of which the appellants are seeking regularization is subject matter of acquisition, therefore their application seeking regularization cannot be entertained. Paragraph. The learned paragraph. Apart from above, it is relevant to mention that the appellants do not have any vested right to seek regularization of the land which is in their unauthorized occupation. Besides this, apart from this, for a cogent reason, their claim for regularization has been rejected. The order passed by the learned single judge therefore does not call for any interference. The appeal fails and is hereby dismissed. So simple, right? So simple. Nothing, no inconvenience. Every inconvenience disappears. Now similar inconvenience will disappear just now. There is no inconvenience, right? Correct.
ಇದ್ರಲ್ಲಿ ನೋಡಿ ಎಷ್ಟನೇ ಇವಾಗ
This intra-court appeal has been filed against an order dated 28th of January 2014, passed by learned single judge, by which read petition preferred by the appellant, challenging the order dated 13/9/2010, passed by State of Karnataka, Government of Karnataka, has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellant claims to be the owner of the land, and in possession of land measuring 17 acres and 21 guntas, of various survey numbers at Datta Galli, Mysore district. Full stop. The aforesaid land, along with another land measuring 3 acres and 28 guntas, were sought to be acquired by the Mysore Development Authority for the purposes of formation of the road and Datta Galli layout in Mysore city. Paragraph. A preliminary notification under section 17 within bracket 1 of the Act was issued on 15/3/1990, which was followed by a notification dated 25/4/1991 under section 19 within bracket 1 of the Act. The validity of the said notifications was challenged in writ petitions, namely WP number 10621-629/1998, which were allowed by an order dated 17/9/1998, and the final and the notifications were quashed, and however liberty was reserved to the authority, Mysore Development Authority, to pursue the acquisition if so advised from an appropriate stage. Paragraph. Thereafter, subsequently, a notification dated 4/10/1999 was issued. 4/10/1999 was issued. Full stop. Thereafter, the appellants claim to have purchased the lands through registered sale deeds dated 28/9/2001. Full stop. The Mysore Development Authority had submitted a representation to the government acquisition under 28/9/2001. Full stop. Thereafter, a subsequent notification dated 22/7/2002 was issued, which was assigned by the appellant in a writ petition, namely WP number 30425/2002, which was allowed by an order dated 28/8/2007. The order passed by the learned single judge was upheld by a division bench wide judgment dated 4/12/2007 in WA 1995/2007. Paragraph. Paragraph. Being agreed, the Mysore Development Authority filed a special leave petition before Honorable the Supreme Court, namely SLP number, Civil Appeal number 2934/2010, which was partly allowed by Honorable the Supreme Court by an order dated 1/4/2010. The impugned notifications dated 22 July 2002 and 15/9/2001 were quashed. And the matter was remitted to the state government for consideration of the appellant's application for withdrawal from the acquisition. Paragraph. The aforesaid order, paragraph, is in the state government by an order dated 13/9/2010 rejected the application submitted by the appellant seeking withdrawal from the acquisition. Full stop. The aforesaid order was challenged by the appellant in a writ petition which has been dismissed by learned single judge. Paragraph. In the aforesaid factual background, this appeal has been filed. We have heard learned counsel for the parties at length. It is right that the state government can withdraw from the acquisition provided the possession of the land in question has not been taken. Full stop. On perusal of the record, former learned single judge has found that on 8/12/2000, the possession of the land in question was taken and a mahazar has been drawn, which was placed on record. Full stop. The learned single judge has also referred to the communication dated 18/12/2000 sent by Divisional Commissioner to the government, wherein it has been stated that the possession of the land in question has already been taken. Full stop. Thus, the power to withdraw from the acquisition of the land could not have been exercised by the state government. Full stop. There is no infirmity with the order. No infirmity with the order dated 13/9/2010. The learned single judge therefore has rightly declined to entertain the petition. For the aforementioned reasons, we do not find any merit in this appeal. The same fails. What happens if memo IA dismisses? What happens if the appeal itself has been decided on merits? What happens to IA? It survives. See, I mean, how simple it is, right? All inconvenience, everything has disappeared. He can now leisurely recover from the throat infection. No hurry.
Highest authority state level consider finding that the position is taken.
Lame excuses, right? Not- Hey, you have been telling like several times, right? How many dates? Amicably settled. It's all. 5/9/2022. 5/9/2022. Oh no. 5/9/2022. You have been seeking adjournment. This is list of dates he is giving. Please go ahead. No, we are 5/9/2022 and order sheets are being typed and we are signing it and it is again being sent back to board branch, coming to court, again adjourned this thing. 1, 2, just a minute. 1, 2, 3, 4, 5, 6, 6 adjournments. 6 adjournments on the ground that amicably settled. There has to be they withdraw it. Withdraw it. Settle, then withdraw. Otherwise, argue. No. See, Mr. 25th January 23, we had said, just a minute. We had said 4 weeks time by way of indulgence to report settlement, failing which appropriate order shall be passed. So it's not, you are not reporting settlement. Please argue. We are bound. Maybe today only you have to argue. Nothing ultimate. No, that doesn't mean that for 6 times we will keep on adjourning. We have told you 6 adjournments, right? September 2022, almost. Please argue. No, last indulgence, Mr. You may not attach any sanctity to our orders. We are bound by it. We have said, we have said that it will be failing which appropriate. We don't know. Please argue. Or we will ask him the facts, then you can make submission. If you have not read it, then we will ask him the facts. Please. No, we are not agreeable to adjournment. It's not in learned friends. Even if he says, I agree for adjournment for 4 years, we will not grant adjournment. No, we will not grant adjournment. No, Mr. Please see the order. Six times it has been adjourned. Just a minute. Have patience. It's not that we are acting unreasonably. 6 times adjournment have been granted. Last date, 4 weeks time by way of indulgence to enable him to report settlement, failing which appropriate order shall be passed. What appropriate order? We can only this thing here and decide it. Please argue. It's either admitted or goes, whatever happens. It's only for admission. Please go. What happened to 17, Mr. 17?
That is disposed of.
18 and 16?
16 and 17.
16 was 25.
No, not.
16 will be remanded back to
16.1.
16 and 16.2 petitions, both are remanded.
Okay. I didn't know.
Yes.
That we have done, that stage we have crossed. No, Mr. We can't adjourn the case like. Mr. Riga, we told you that this order, we are trying to tell him, he doesn't seem to understand. This order binds us. 6 times adjournment has been granted. Last date we said finally 4 weeks time, failing which appropriate order. There is no application to recall or modify that order, number 1. Secondly, this order binds us. We cannot flout our own order. Supposing if we flout our order, what do we tell you? And what do you tell your litigants? Simple thing. What can be done? There is no application to modify the order, whatever XYZ reasons. There is no this thing. So this order binds us, right? We cannot flout our own order and grant adjournment merely because you are agreeing. This is not. We told him that even if you agree, it will not be granted. Please go ahead, or we take it to be closed. Please. Please.
Article 7, 5, number 3 was granted in the year 1981. That is authorized.
Form number 7 filed on 31/12/1974.
And there what happened? That came to the set aside and the matter is the plan for fresh disposal on year 1985. There also Indian food again the application filed was allowed and this was called very well by the landlord. India. And the other is, the 1 7 that the land is. That the land was given to the tenant for planting, nourishing, cutting and removing the trees. And see, it does not fall within the category of definitely. Indian legal water. What the problem to my vendor here by applicating it towards. India would say the same land of society. And society has formed the layout in a lot of sense. In year 2003, the society came to know that such a petition was filed by the landlord and the same was allowed.
What is the order under challenge? No, what was challenged before Learned Singhal? 5/10/2020. 5/10/2002 was under challenge. Got it. Yes. Yes, please.
Why didn't you all part of the act? Planning also is a measuring.
From
Although, nothing to happen that it is. Responding to one is internal law. The receiver is allowed to contest the matter. Our report appeal against the order of the hearing. We don't have a position of the same life. Here to say. Had no knowledge of the art and number 2.8. That is and story of making on I would. Of the land. Or somebody also payment of damage. Because part is questioning by me, because the fee. How now, the match is pending RSA, filed by the That will not be. I'll refer you to that. Now, there was an agreement between the landlord and the tenant. Yeah, the decisions of the law will control to be. What is the order? It was one of some renewal of it can be nourishing, but you can remote sharing the self also. And in the meanwhile, if there were to be any crop, serious growth as the undercrop, what to share with that. But other people they said that you are interested to go increase. It doesn't follow.
Why did you purchase the land despite knowing that litigation is pending?
And
Not
what
knowing.
has happened? What has happened with us? In year 2005, we can not up for the issue smaller to be the tenant. We always see all commercial. We're showing 1981 law. But Tahsildar will secretary of the land review. There is no question of giving up the no next. The child and the superior, his land, he'll send the property. He sold the property to Manda. Manda sold the property to me. So the question would be, this pendency of the litigation. But not moved to this after. But to safeguard the interest of the authorities, side, we want people to settle them. As some was suggested, you are also keeping of women here, and they are actually they are really in favor of.
But you are unable to settle, right? That's why you are arguing. Right.
Paying the money and RSF, where we can actually have it quickly. But now there is a possession. My particular position is, I cannot pay market value of this property to pay 30 crores. And I have to afford for it. Say, I can't afford for it. Only the value of compensation. I will pay 8 crores. That has to be reduced to society. That section of 8 crores from the party. Then you have because you are sold the property for no profit, no loss. But that is my lord, what we tell. It is only end of this month. Probably we come with the document and we get the degree in RSF. Why this? When it says something, you put document where it's got the document. And they will not pass out. Okay, so for that we need to go for right. We don't want to take the because myself is very large, not one. 2 or 3 times you have to sack whether the and my friend, I'm representing. So reduce the counter payment and passing on the rate. Because we are purchasing property during payment of it. Or save for the interest of the budget they have to keep the member.
That's all.
So the last, my request, the last amendment is the market to be for loss. So the last
That is ruled out. September 2022 onwards.
On 15 months.
Because you told settle. You withdraw it if it is settled. We don't know. Did you file an application saying that this order be modified? We told you, we pass in your. No, no, no. You have not filed an application. Then again you will say, court had suggested me to file an. You are saying that court has suggested to go for compromise. We are not suggesting. If the land doesn't belong to us, we are not the society. Why will we suggest? No, no, we have to decide, Mr. Agriculture. What agriculture? No, you said court, this thing, court told us to compromise. We didn't tell you anything. We are only telling the reasons why we are not granting adjournment. That will be recorded in the order sheet also. Yes.
Definition. Aquaculture, agriculture, the raising of crops, grass and water farming, dairy farming, feeding of grazing, but does not include the feeding of the only. Where the other single axiom, you will get this, saying that you have to live. Fitting and feeding of, but not. You may say that. Why don't you have candidates? And then after this land is removed, again they have to make ready this land for the purpose of replanting, replanted. They have nourished and what they say, that India made 1969. Yeah, surrendered the position of the land. And thereafter, their transport remained in the land. I won't actually tell you it. But the property was not. Made by the government in page 28 of your. Whether it is taking care of all. Then, next paragraph. It is dramatically very and complicated or a pretty bad or correspondingly. Para but thinking of definition of agriculture, the cultivate and the cultivate percentage does not in place. It will take off the surface and the building of. The definition of agriculture in this and raising of crops, not as farming, direct farming, feeding, raising, but however does not. The definition of cultivate leaf is referred to single or alternative leaf. Land or the explanation to the
What is your submission?
Not only between
It's an agricultural land.
well, remove and already plant, and then replant plant, and thereafter take care of it, and reach them, and thereafter continue to share that second. And further is out. There is also a decision in the law. Then the because of the serious of goal as the suppose well, in the line. So it comes from. But that is the main. That we need to be rewarded. So the standpoint to taking a review, not planting, and then thereafter. Always.
That is condoned. That is condoned. You argue on merits. We have seen it. Will you tell us your submission?
And the land and the give it back. That was the agreement. It's not to page 27. The court has a combined degree of definition. Page 30. A combined degree of definition. To cultivate and cultivate for taking care of the surface of the what was given to the person which is a person who has taken is only to taking care of the taking the definition of the
Page.
Then I can. So 590.
Page. What is the deed dated? 5th August. Okay. Again. Okay.
98, my concern.
Husband's petition partly allowed. Okay, husband's petition partly allowed. On the ground of cruelty.
Petition. Decree of divorce, calendar decree of divorce. When is already died. So you have to see that.
Writ counsel for the appellant submits. Yes, the writ counsel for the appellant submits that he does not intend to press the appeal on account of subsequent events. The aforesaid submission is placed on record. The appeal is dismissed as not pressed.
Very dated,
7/5.
Yeah, so
RFA should go before regular bench.
Roster bench, roster bench.
It should go before regular bench. Let RFA 19.1, let RFA be posted with the regular bench, roster bench. 1 minute. Wait. Item number, what is it? 80. WA 6401/2017. IA 1 of 2017. All right. This intercourt appeal. This intercourt appeal has been filed against an order. Intercourt appeal is filed against an order dated 30th November 2011, passed by learned single judge, by which writ petition preferred by respondents number 1 and 2 has been allowed, and the order of the land tribunal dated 5/1/2002 has been quashed. Full stop. In order to appreciate the difference of the appellant's relevant facts need mention, which are stated herein after. The subject matter of this appeal is land bearing survey number 150 and 151, measuring 4 acre and 38 cents. Subject matter of this appeal are, no, this appeal is like land bearing survey number 150 and survey number 151, measuring 4 acre and 38 cents, and land measuring 5 acres situated at Vetnahalli village. Vetnahalli village. Vetnahalli village. Village, Kundana, Hobli, Devanhandi, Taluk, Bangalore. Other big MP Patalappa, Chikka Patalappa submitted an application in form number 7. The provisions of Karnataka Land Reforms Act 1961, herein after referred to as the Act, seeking occupancy rights in respect of land in question. Full stop. The tribunal by an order dated 21/10/1981 granted occupancy rights. Full stop. The order passed by the land tribunal was challenged in a writ petition, namely WP number 3893/1983, which was allowed by an order dated 3/1/1985, and the matter was remitted to the land tribunal. Paragraph. Thereafter, the land tribunal by an order dated 5/10/2002 granted occupancy rights. Full stop. Occupancy rights. Thereupon, a writ petition was filed by one E.S. Krishna and E.S. Srisalam by respondents number 1 and 2. Respondents number 1 and 2. Respondents 1 and 2, namely WP number 2538/2003, in which the order passed by the land tribunal was challenged. Full stop. During the pendency of the appeal, during the pendency of the writ petition, the appellant, namely Telecom Employees Housing Society, herein after referred to as the society, purchased the land in question. Full stop. Purchased the land in question. Paragraph. Thereafter, the society entered into a confirmation deed with respondents number 3, with its vendor, with a confirmation deed with its vendor on 5/8/2003. 5/8/2003. Stop from governments of the from the recitals contained in the aforesaid confirmation deed, it is evident that the appellant was aware about the litigation which was pending between the parties. Full stop. We said writ petition was allowed by learned single judge by an order dated 30th/11/2011 and the order dated 5/10/2002, granting occupancy rights in respect of respondents 1 and 2 has been quashed. Learned single judge by an order dated so and so quashed the order of the land tribunal, and the writ petition was allowed. Right? In the aforesaid factual background, this appeal has been filed. Paragraph. Learned counsel for the appellant submitted that learned single judge ought to have appreciated that the lands in question were agricultural lands, and therefore the learned single judge grossly erred in holding that the grossly erred in quashing aside in setting aside the order passed by the land tribunal. Full stop. On the other hand, learned counsel for respondent submitted that land bearing survey number 150 and 151 were not agricultural lands, and the original respondent number 1 was not a tenant in respect of land in question. It is further submitted that the appellant who was fully aware about the litigation pending between the parties, has purchased the land and cannot step into the shoes of the person who is claiming to be an occupancy tenant. Occupant who is claiming to be a tenant. Claiming to be a tenant seeking occupancy rights. It is further submitted that the order passed by learned single judge does not call for any interference. Paragraph. We have considered the submissions made by learned counsel for the parties and have reviewed the record. On the basis of the material available on record, it is evident that in a survey it was found that on the land in question, the crops are not grown, crops are not grown, and the land in question is a dry land. The land was being used for growing casuarina trees. Full stop. It has full stop. From the material available on record, it is evident that original respondent number 1 has failed to establish that he was in cultivating possession of the land on the relevant date, that is on 1/3/1974. Full stop. There is no material on record to show that the respondents number 1 and 2 were ever inducted as tenants and were in cultivating possession of the land in question as on 1/1974. Full stop. Paragraph. Besides this, besides aforementioned here, apart from this, it is relevant to mention that the appellant society was aware about the litigation pending between the parties, and notwithstanding the pendency of the litigation, the society has purchased the land in question in the year 2006. Full stop. Purchased the land. Full stop. The society cannot get into the shoes of the person who is claiming to be a tenant and is seeking an occupancy rights. Paragraph. For the aforementioned reasons, in our we agree with the conclusion arrived at by the learned single judge. In the result, we do not find any merit in this petition. Appeal the same fails and is hereby dismissed pending interlocutory.
December.
Saying that it is closed.
I filed a memo on last Friday.
Only that.
Infectious. Oh, that's why you are here. Otherwise, he would have appeared.
Stay.
1 minute. 1 minute. We will go to the facts, but have you seen you must have seen the memo. So supposing if the order of remand, we have got your submission. If the order of remand is set aside, everything goes and you succeed in the subsequent appeal also. this order that it has, this order that it has become infructuous should be passed in the subsequent writ appeal, not this. Understood. Yes. Why nothing to say? You have everything to challenge the order granting occupancy rights. That only shows what is the value of the land. That only judgment shows what is the market value. Lighter vein, Mr. You should learn to enjoy, right? That only shows your appearance and this judgment. What is the market value of the land? Nothing else.
That is not enter. It is second round of litigation. Tribunal granted occupancy rate for rent. That was also valid. Third time in the tribunal conducted this.
Which that case where the learned single judge said principle of live and let live. Live and let live.
Out of the upward portion of procedure, oneself and any part under compensation. The provision of sufficient to the previous landlord himself indicate for recovery of the respect of 105. At an undisputed point, these documents are there. That is the reason not to make it by it was wrongly. Therefore, it is no doubt of the order of the the structure of the subject, the identity, and the case notice. Participants today cannot be separated from the Confined the officer in the so for a party can be after this that party can be eliminated. Other than that, other was upgraded to the direction. That is part of the advocate cannot respond from not the people is simple demand. Therefore, they are not parties are not advised. When the matter was stated, the execution was filed. The everything got a letter of the order. Therefore, it is not a that they are not copy of the compensation for
correct clerical or arithmetical error in the order.
And 45 and 40 cents and 55 cents are not inseparable. Secondary court also increases. Based on the criminal set. This process of findings of the tribunal. It is not and why evidence is that 45 cents in the first of October. After 3 years, it is not taken 1,000 as after citing the reasons. So we so may not indicate a reason to be recorded. That's not the implementing the order. The occasion for the single. Cease my explain. The last. Yeah, started. He's noted. Son of the court said, surrender 55 cents. Identify the mistake. Give it to the tenant. Partition it to the landlord. Attend to the order.
Proper, lack of proper advice.
What changes to the market? The duties of the father. Not served. Ever complete mission of the paper corresponding paper. I think you are not. Has been observed. The body cannot. Description of property. Not required. Last date indicated for listing. Constitution of the land. By virtue of a new surveillance, new subsurveillance, new all these not being followed. Section 6 of case, in the area of 50 number of property, that is 10 issues. There are no change of the change of the instead of 50 places, you are in possession of 80 places, you are 1 place, 50 places. As fast extended, I said, I mean, what?
Yeah, we have read it several times.
ಹೇಳುವುದಿಲ್ಲ ಮತ್ತೆ. ಹೇಳುವುದಿಲ್ಲ.
Yes, Mr.
Am I audible, my lord?
Yes, yes.
First of all, my lord, there is a delay of 3,000 and odd delay in filing the appeal. That is not properly explained according to me, my lord. My second submission, I filed a memo on last Friday saying that appeal has become infructuous. A fresh order is passed and the appellant has filed a fresh petition which is pending before this court. Now, third submission, your lordship may kindly take page 59, my lord, 59 of the paper book. 59. Now, that is the form number 7 in translated copy of form number 7, page 59, my lord. Page 59. My lord, he has been granted extensive lands belonging to me. Now, the contest is only in respect of 84/1. 84/1, it's about ninth item, my lord, in the list. 30 cents. 84/1, 30 cents. In the next page, page 60, my lord. 84/1A, 25 cents. 25 cents. The claim is only for 55 cents. Claiming 40 cents, which is in the earlier order. In the latest order also, this is rejected, 40 cents, saying that his claim is only in respect of 55 cents. 55 cents are granted. Learned single judge just directed the tribunal to hold a survey and include his house and cattle shed, even if it is not there in the 55 cents. Now in the revised order, house and cattle shed is added and given to him, apart from 55 cents.
Much he was given?
55 cents, including his house and cattle shed in the fresh order.
How much he was given?
55 cents only. The survey says this house and cattle shed is within 55 cents. That is in the fresh order. Of course, that is under challenge before this court.
You said excess has been given. That's why we are asking.
Not his claim is only for 55 cents.
So he has been given 55 cents only.
Yes.
You said
He has claimed in the survey, he has claimed more. Villa. His present claim is 95 cents.
No, so he has been given whatever he has claimed, right?
Yes. That's all my submission.
No,
That's my submission.
He has not given something which he has not asked for.
Yes.
Yes.
That's all my submission. And more than that, my lord, this appeal is infectious according to me. I have filed a memo accordingly.
Anything else? That's all. Fine. Where you have been. This arrangement should continue, right? Shall we say that it's during pendency of appeal? Yes. Third learned counsel for the parties, the interim order. Mark the presence after hearing learned counsel for the parties, it is directed that on alternate Saturdays, the appellant shall be entitled to spend time with the children between 4 p.m. till 6:30 p.m. Subject to aforesaid modification, the interim order granted on the 27th of January 23 shall continue during the pendency of the appeal. The beginning, right? Appeal is admitted for hearing. Then third learned counsel for the parties. Yes. Record is there. Office is directed to secure the record of the family. You should also do something, right? Find out, we want you to be on your toes to find out when the record has come, to give these people some work so that they can draft an application for early hearing, besides standing by your side in the court, right? 22. 30. Appeal is admitted for hearing. Record. Office is directed. Secure the record of the family court. 23. Only direction. DP Muddalla. Pay scale. You accepted. It's like lawyer becoming a judge. Thereafter having accepted judgeship, he cannot say that I should be paid whatever I used to earn as a counsel. It's like something like that. Yes, please. Yes. H.
That's it. One page. If you, I mean, in addition to all the there I was. And I reached stagnation in that scale because the scale is 0.1900. Therefore, promotion in
You could have.
yes. I stagnate in that box. That was but before considering all this particular with this explain the number 30. The meeting was hot and we picture of the other present and we explain on what basis this 1000 parties because earlier they were working not as a worker. That means that they and they get some amount. So that fixation of salary, they take in 3 months average. This was the scale. And according to that, all those things explained number 40. That is the meeting explained. And after explaining the meeting my heart, again the next year they find another repeat. It is repeated minus to the repeated and the one that whatever that field and they are the and further I also it has a board also otherwise not happening that home because we cannot join. We have to want one more independent not we use that and this matter is third and this matter is number 19 matter.
Where are you reading? Page 90.
19, 19.
That was the previous was permanent, didn't. The applicable relocating are located in our which is 1040 100. These water systems were given to and they were promoted. That was the people and the very they cannot now. It is after about 10 years.
That's it, Mr. Anything else? That's it. Before, appeal is admitted for hearing. Appeal is admitted for hearing. Office is directed to secure the record of the family court. Right? What can be done? Where is Mr. Amicus? He has left. Huh? See what to do. We want to admit the appeal. Counsel for appellant is praying for adjournment, saying next week. Appeal lies, right? The law provides. There is nothing to argue. These people do not understand this also. The adjournment culture is ingrained to such an extent in their mind that they will come in the court and seek adjournment. Order has been passed. If you don't understand, fine. We are not here to explain it to you. Fine. Next, admitted for hearing, right? Record. Hello? Yes. Wife's appeal. Appeal is done for the appellant record perused. Appeal is admitted for hearing. Office is directed to secure the record of the family court also heard on IA 1 of 2022. In the meanwhile, operation and effect of impugned judgment and decree insofar as it directs dissolution of marriage shall remain state.
Much obliged, by us.
Appeal is admitted for hearing. The Red Counsel for respondent praise warrant is granted 2 weeks to enable him to file objections to IA 1 of 22. After admission record. After admission, office is directed to secure records of the family court. Then, correct? Yes, madam, correct? 28 appeal is admitted for hearing, issue notice record. 29 what?
Please, ma'am.
Appeal is-
allowed.
Appeal is admitted for hearing, issue notice, office is directed to secure the record of the family court heard on IA 1 of 23. In the meanwhile, it is directed that operation same order shall remain state. Witness. This intra-court appeal. This intra-court appeal has been filed against an order dated 30th June 2021, passed by learned single judge, by which writ petition but by the appellants has been dismissed. Paragraph. Facts giving rise to filing of this appeal briefly stated are that the appellants were appointed as weavers in Karnataka State Silk Industries Corporation Limited, hereinafter referred to as the corporation. Full stop. The appellant number 1 was appointed as a weaver on 28/6/2083 and 28/6/1983, whereas appellant number 2 was appointed on 3/3/1983. In the year 1984, the appellants were absorbed in the services of the corporation, and on 21/11/2002, they were promoted as design helpers on a pay scale of rupees 1040-1900. Full stop. Paragraph. After about a period of 10 years from their promotion, the appellants demanded fixation of their pay from the date of reporting to duty and to grant them the benefit of time-bound advancement on completion of 10 years and 15 years of service, and consequently sought fixation of their basic pay. In the pay scale of 1280-2375 with effect from 23/11/2002. Full stop. The aforesaid claim was rejected by an endorsement dated 5/12/2015. Paragraph. The appellants challenge the aforesaid endorsement in a writ petition, which was dismissed by learned single judge by an order dated 30th/6/2021. In the aforesaid factual background, this intra-court appeal has been filed. Learned counsel for the appellant. Learned counsel for the appellants. Learned counsel for the appellants submitted that on promotion, the appellant's scale of pay ought to have been protected and they are entitled to one increment to their basic pay. It is further submitted that the aforesaid aspect of the matter has not been appreciated. So on the other hand, the counsel for respondents has submitted that this is the third round of litigation for the in respect of the claim which has been made by the appellants. It is further submitted that the order passed by learned single judge does not call for any interference. Paragraph. We have considered the submissions made on both sides and have perused the record. Full stop. Appellants were admittedly appointed as weavers and were promoted to the post of design helpers. What is the annexure R1? By an order dated
post remand. They have conducted meeting and then hearing them. it was
By an
posted.
order dated 31st March 2003, comma, by an order dated 31st March 2003, comma, the post of design helpers was created by way of an amendment along with applicable pay scale and the mode of recruitment. So the aforesaid office order clearly provided that the scale of pay of design helper would be 1040-1900. Full stop. Paragraph. In compliance of the aforesaid office order, comma, the appellants were promoted to the post of design helpers. Full stop. Design helpers and were provided the pay scale of 1040-1900. Full stop. After a period of 10 years, comma, after a period of 10 years from the date of their promotion, that is on 21/11/2002, comma, the appellants for the first time contended that they are entitled to a higher scale of pay. Full stop. The learned single judge has rightly held that having accepted the promotion as well as the scale of pay, which was attached to the post of design helper, comma, it is not open for the appellants to turn around and to claim a higher pay scale. Paragraph. We do not find any reason to interfere with the order passed by learned single judge. In the result, appeal fails. One minute. Heard on IA number 1 of 20 and application seeking condonation of delay. This court appeal has been filed against an order dated 28th of November 2011, passed by learned single judge, by which writ petition preferred by the respondent, respondent number 1, respondents 1 to 5, comma, challenging the order dated 29/1/2003, passed by the land tribunal granting occupancy rights in favor of the appellant has been disposed of with the direction to the land tribunal to appoint a survey and to carry out and to carve out the area which is in occupation of the appellant, including the land on which the area measuring, carve out the area measuring 55 cents, including the which includes an area on which cattle shed or as well as the house of the appellant is situated. Paragraph. In the application, we have heard learned counsel for the parties at length. In the application, seeking condonation of delay of 3,000, how many days?
3008.
3,008 days, comma, following governments have been made. In the affidavit seeking condonation of delay. Huh? In the affidavit seeking condonation of delay. In the affidavit filed in support of the application seeking condonation of delay, following governments have been made. Paragraph 3. Paragraph 3. Thus, it is evident that no explanation has been offered for inordinate delay of 3,008 days in filing the appeal. We are conscious of the fact that the courts are required to take a liberal view for condonation of delay so as to advance the cause of justice. However, nonetheless, the litigant is under an obligation at least to furnish an explanation for the delay. In para 3 of the affidavit, no explanation has been furnished for delay of 3,008 days in filing the appeal. Full stop. Therefore, we hold that no sufficient cause is made out for condonation of delay of 3,008 days in filing the appeal. Accordingly, IA number so and so is dismissed. Right? Paragraph. Even otherwise, paragraph. For yet another reason, no interference is called for in the order passed by the learned single judge. Full stop. It is pertinent to note that by an order dated 28/11/2011, learned single judge has upheld the order of grant in favor of the appellant and had remitted the matter only to carry out the measurement. Full stop. It is not in dispute that in pursuance of the order passed by the learned single judge, a fresh measurement has already been carried out and the land tribunal has disposed of the form number 7 filed by the appellant by an order dated 8/8/2016. Full stop. It is also not in dispute that a aforesaid order has been assailed by the appellant in a writ petition, namely WP number 44617/2016. Full stop. For the aforementioned reason also, nothing survives for adjudication in this intra-court appeal. Paragraph. Accordingly, the same is dismissed.
Matter, circular 1, after April, management.
Now for the
Available warrant.
somebody said right also. Huh? What is it? Tell us. We don't remember exactly what is. No, when was marriage took place? Date of marriage. 14. When was the petition filed? On the ground of cruelty and desertion. So what is the plea with regard to desertion when she has left? No children born out of marriage. Son, when was he born? Son is with the mother. What is the desertion like? Plea or desertion? When she has left you? Acha, you are the wife. It has been decreed on the ground of cruelty and desertion both. So, what is the plea with regard to cruelty and desertion? Paragraph number, tell us what. 18/11/2010. Which paragraph of the petition have you said so, Mr. Desertion? You don't have. What did you do after she deserted? Did you give a notice? When? Mr. 15/11/2010, she has left you. So what prior to 2010 means nothing.
And under the said petition, the 250,000 was paid. After having tried this, the appellate thereafter did not attend to the proceedings.
13B, just 13B petition filed on.
It was filed on 16/12/2010.
5 lakhs permanent element. Appellant didn't appear.
This was report on 7/1/2012. Because the
Mr. The cruelty, what did you, what is the desertion plea or the
that
and what is cruelty?
The company of the responding jury for the birth of the child. They are not, she did not come back. And she has been residing there and there was no relationship activity. That is one. The other one is that is the only most raised so far as cruelty is But it's also been pointed out to us that despite having agreed to dissolve the marriage and having filed a petition for the court and having taken the portion of the annual or the amount agreed towards the permanent annual. Thus, the appellant did not even continue with the proceedings also. He let the matter to get dismissed for refund after about nearly 1.5 years. The other one.
Does it amount to cruelty? Not appearing in a petition under 13B?
Having
What?
having
No, so does it amount to cruelty? What is the argument? Having agreed. No, this you are telling us for the third time. So what does this mean? It proves cruelty. What submission, what is it? Third time we have understood, right? Third time you are saying agreed. This thing did not appear 1.5 years kept pending. So what? It amounts to cruelty. So what? Any case law? I haven't come across. We haven't come across that this amounts to cruelty not appearing. New dimension.
This is not pleaded.
Not pleading, you're pleading. Look, well, give it to.
Show us one line where you have pleaded about cruelty and also date of deserts. Only 2 sentences.
No, what is mentioned?
About desertion also date specifically you have stated. No, sir.
What cruelty? Cruelty. That's the end of the matter. No, pointed out. What? Mister, you are saying that June 2009 she has left the matrimonial home. The family court records a finding in your favor saying that November 2010 she is leaving. Read. Where is that deposition? RW1 boy, where is the admission? That she has not been driven out of the matrimonial home and is residing separately on her own volition. Where is the admission? That is then.
Take this.
Family court refers to the statement, Mr. You have to read statement, right? So
Says
you have
that
to, Mr. Amicus, we have to tell the council what to read, then he will read and oblige us. Right? He doesn't have the petition, he doesn't have the statement of objection. It's only from the judgment he is ready.
have said for deciding, but it's not. Deciding separately. Deciding separately. Read for it.
ನಾನು ಅರ್ಜಿದಾರ ಈಗಲೂ ಜೀವನ ಮಾಡಲಿಕ್ಕೆ ಯಾರು ಇದ್ದೇನೆ ಎಂದು
It's
You
not
will have
said.
to translate it in English also, right? Yes. She said something, right?
No, she has denied the awareness, saying that we can't.
and suggested also.
She's ready to, she has said she's ready to speak. You read the cross examination.
After
You
that,
read
read,
her.
that read once again, you read. that.
Team
11.
Like she has said something.
What it means after that date, what she has stated, that I am residing separately from 15/11/2000. Further, what she has stated, you please translate it.
Making a false statement. She's to decide with people. Not to give. That will not be any conflict of interest. As
You read the whole cross examination. Find out. She must have said somewhere. Deciding separately doesn't mean that desertion. Reciting, please understand, reciting separately doesn't mean desertion. There has to be an intention on her part to this thing abandon you. And that, I mean, supposing if you thrash her daily and she goes out or leave the matrimonial home, you cannot say, oh, she has deserted. It's not that. You have to prove the. This is further hearing. No, we don't have any other work to do. Go through. This is the place where you should prepare the case and argue. Why waste time? The other time, and weekends are meant for doing something better. You should prepare the case here only and argue. We are accustomed to it.
ಮೂಲಕ್ಕೆ ನಾನು ಮೊದಲೇ ಮಾಡಿರುವ ಬಗ್ಗೆ ಹೇಳಿರುವ ಬಗ್ಗೆ ನನಗೆ ಈಗ
Yes.
Winter. Something more.
Evidence is on the evidence around this filing of identification. Understand, please. So, please read the paragraph which says about the desertion. Cruelty is one aspect what you already stated. That she has come, she has signed, she has taken the money, she has not come forward. It's it amounting to cruelty. That we understood. What about desertion, you please? Yes, he has stated, admitted clearly that where you have established that she has voluntarily left the house and she has no intention to come back. That part you just shows. So, we understood. We understood. Millie Court in para 16 has held that she has started residing from 15/11/2010. This admission is believed. That we also agree that she is residing separately. So where is her admission to show that voluntarily I have left the house? Because whatever reason, voluntarily I have left and I have no intention to come back. Where is that admission? If that admission is there, or in your pleading, or in your evidence, you show that. Or wherever, in evidence or pleading, you are not pleaded, no specific date of. You have stated 9, family court has taken as 10. Deciding separate. Deciding separate.
So this day, court is stating that 2 years period. From 2010.
That statement is sufficient to come to a conclusion that there is a desertion. Ingredients are met. Please read the section. So that could be or could have. Straight way come to Roman I. Desertion means
What does this expression desertion? It has a definite connotation in law. The query by my lord is, what does it mean? obviously you have not brought any case law, nothing. That we will have to find out what is it mean. It's not, there are judgments and judgments saying what is desertion. The evidence on record does not establish the plea of desertion. That's mere separate residence does not amount to desertion. You are required to prove the intention on the part of a spouse that she has left the matrimonial home and has abandoned you and has no intention of coming back. Merely separately residing for X, Y, Z reasons which we don't know does not amount to desertion. That's the legal position. That's it. Say no, you are not interested.
What about a child? 2.5 lakh rupees now you will pay entire amount. Now you will pay 2.5 lakh. This 2.5 lakh rupees including the wife and child. Wife and child, both you are paying as a. Child is with you. 2.5 for both 2.5 lakh rupees for rest of life. That reason only why what?
Nothing. Permission. Don't take the trouble of doing anything. Want to argue? Give the file. Give the file, this file 37. You want to argue right now? Whose family? 37. Learned counsel for the other. Who is appearing for respondent? Who is for the appellate? Inform. Learned counsel for respondent submits that he has suffered a bereavement in the family. He therefore prays for adjournment list after 1 week.
explain ಮಾಡ್ಬೇಕು.
High Court government pleader pays for a short accommodation to enable him to ensure that the available warrant served on the respondent is executed based on what date? 2nd March? 2nd March 23. All right. Kapil. Ah. Oh, good. What a pleasant surprise. That's how it should be. Huh? These appeals have been filed against common judgment dated, what common judgment dated 31/1/2018, passed in MC number 10 of 2018, paragraph. 5 and 10. 5 and 5 of 2008 and 10 of 2008, paragraph. No, you say parties along with their counsel present. Learned counsel for the parties, then line below, learned counsel for the parties have, these appeals have been filed, etc. Learned counsel for the parties have filed the joint memo stating that the parties are, that the dispute between the parties have been amicably resolved and they are living together. Paragraph, the aforesaid memo is taken on record. The appeals are dismissed as withdrawn, right? Pending interlocutory applications are disposed of. Get their signatures matter. For final hearing, number 31. Kamath, Nataraj Ballad.
Your Lordship, appearing on behalf of the appellant in the first appeal, Your Lordship. This court has last time directed the respondent in this first appeal to file affidavit, which was not filed in the proper format as per Rajneesh versus Neha. We have not been served with a copy of the same, Your Lordship. It was supposed to be filed on 24th, and we were supposed to be served also on the same date. We do not have the copy of the same, Your Lordship.
Saturday. It is 25th. Have you supplied a copy to them?
Your Lordship, we were supplied with a 2-page affidavit, and ITR returns in that was not legible, Your Lordship. The whole point this court ordered for a affidavit filing was because the ITR returns were not filed in the earlier affidavit.
Third counsel for the applicant, grace for and is granted a week's time to enable her to supply the copy of affidavit filed on behalf of the learned counsel for respondent, right?
Respondent.
Counsel for
In emergency is applicable. 3916.
learned counsel for respondent in MFA 3916/2016 submits that she has filed an affidavit.
Your Lordship, I am the respondent in 3.
In this is
MFA 3916, appellant. Current counsel for the appellant in MFA 3916/2016 submits that she has filed an affidavit in compliance of the order dated 17/2/2013, on which date on 25th February 23. However, she prays for and is granted a week's time to enable her to serve a copy.
Your Lordship, if I make one submission, Your Lordship. Your Lordship, the affidavit that they have filed is also not in the right format as per Rajneesh versus Neha, Your Lordship.
That we will
They-
take a call.
Much obliged, Your Lordship.
Tell your colleague. Will not tell her what affidavit, what form to be filed.
Much obliged.
No, do you understand what she's saying? Huh? We look into it.
Grateful, Your Lordship.
Give that file, Mr. Before lunch, which was going on, we will dictate the order in that case.
Sent back. It is draft.
chamber participate.
That's the.
Chamber.
Chamber.
That's right.
I appear for the appellant, my lord. We are negotiating, my lord. Final meeting is fixed on Friday. I have informed senior advocate V. Lakshminaran also. If 2 weeks time is granted, we will report settlement, my lord. I have informed senior advocate.
Last date also you sought adjournment, right?
My lord, negotiation was going on. Now it is the final stage. Friday we have fixed the final meeting. So it will.
Learned counsel for parties jointly pray for adjournment to enable them to report settlement list after 2 weeks. Yes, Mr. Oh, he has disappeared.
My lord, sorry, my lord, sorry, my lord. Sorry, my lord, sorry, my lord.
You should speak clearly so that he can hear.
Yes, my lord.
Yes, Mr.
My lord.
You can't hear.
I can hear my lord, but I could not hear him. Hello.
He's
Yes.
seeking for 6th March, sir.
Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord. 6th March. Yes, my lord.
6th March.
Yes, my lord.
Enable them to report settlement list on 6th of March 23.
Much obliged. Much.
33. When the matter is listed, then only you engage a senior counsel. Tell us why when the matter is listed, then only see last date of hearing you did not appear on 14/10/2022. You didn't appear. After 4 months, it's coming up when the case is called. It's not that you could have engaged a counsel. When did you get this? No. Just want to ask you how you work. You must have got this list on Saturday. Saturday you knew. Huh? What did you do on Sunday and on Monday till 3 o'clock? Waiting for, supposing it would not have been called, you would not have said anything. So we want to understand your modus operandi, that when the case is called on that day, seek adjournment on the ground that senior advocate has been engaged. Then when the case is adjourned, then say that he is out of station or he is unwell. What is this? You tell us why you didn't appear on 14/10/2020. Huh? Line was granted. But whatever you had created some rights in favor of the petitioners. So without extinguishing those rights, how it could have been allotted? Whatever, please tell us. Nothing to do tomorrow. Why? Don't take rest. No. Relax. We have to take a note to do justice. We are doing it. Relax. Ask him to prepare for. We don't know if it goes against you. I'll engage him for arguing SLP. If it goes against you, we don't know. Yes, madam. Who wants it?
This was 72, it was granted, 19.
No, Adam.
No,
This
this is
provision,
74.
this provision has been inserted in 74, right? What was, he was granted in 52 or something? 30, 50. What was the position then? This provision will not apply, obviously. No, in any case, what you want to contend, we have understood that a limited right was created in favor of the petitioner and not any this thing, not title was not conveyed to him. But the fact remains even if it was a limited right, you should have extinguished it in a manner known to law. Then only you could have allotted it to respond number 2, not otherwise. That's what learned single justice, correct? That what's wrong? Nothing wrong. If you ask yourself right questions, you get right answers, correct? Simple. No senior advocate. Senior advocate is not required. If you don't understand what can be done. No, nothing. No tomorrow. Tomorrow never comes. Yes. What I have told you. So, Mr. What is the point? Tell us. What do you know about the case? You have briefed senior advocate, right? No, you have briefed, right? So you know something about what is the case. Tell us. How the land could have been granted in your favor? Simple. Not that difficult case, Mr. On which a senior advocate is required to be engaged. Tell us. So state government admits that Aadhari rights have been granted in favor of petitioners way back in 1915, right? And without this thing extinguishing those rights, how it could have been allotted to you? Simple thing, you tell the answer, the argument in the case. No senior advocate. You tell us how can it be done? We are asking you. Forget about it. We are asking you. No, you understand or not what did you understand? All right, password. Specific. You have to detail desertion, what is required to be proved. Yes. Then to give the specific instances, reality is required to be proved, and what are the elements which a person is required to prove the plea of desertion. You don't have it.
Minutes.
First, we have decided desertion and all that. Justice serenity and all that. It's all written.
Same.
Huh? Yeah.
They really gotta work at site.
Specific instances. What is desertion, Mr.
Person, and you must say.
Ah. You should keep it handy. This appeal under section 28 (1) of the Hindu Marriage Act has been filed against judgment dated 8th of July 2016, by which petition filed by the respondent's husband seeking dissolution of marriage on the ground of cruelty and desertion. Paragraph. Fact giving rise to filing of this appeal briefly stated are that marriage between the parties was solemnized on 14/12/2008 at Parikeri as per Hindu rites and rituals. After marriage, the parties started residing together. The appellant gave birth to a son on 16/9/2009. Full stop. It appears that there was gave birth to a child on son on 16/9/2009. Thereafter, you write, it appears that there was difference of opinion between the parties, and therefore appellant wife went to her parents' home. Full stop. Paragraph. The respondent filed a petition under section 13 of the Hindu Marriage Act on or about 25/7/2013 inter alia on the ground that the respondent has that the appellant wife has deserted the respondent since 16/9/2009 and has not joined the matrimonial home. Full stop. It was also pleaded that the appellant responded with mental and physical cruelty and is residing with her parents since June 2009 without any intimation to the respondent. For also plead paragraph. The respondent, the appellant by the statement of objection in which the factum of marriage as well as the birth of the son was admitted. However, other contents of the petition were denied. It was pleaded that that the respondent is addicted to several vices and used to come home late. Full stop. It was also pleaded that the respondent and his family members have not visited the hospital and have not provided the basic necessity to the appellant. Full stop. It was averred that the respondent used to ill-treat the appellant. Full stop. Paragraph. The respondent, in order to prove his case, examined himself as PW1 and one more witness, namely Prabhakar as PW2, and exhibited 10 documents. The respondent examined herself and did not adduce any documentary evidence. The family court, by judgment dated 8th of July 2016, the area held that the appellant is residing that the appellant in her evidence has admitted that she is residing from the respondent separately from 15/11/2010, and the petition seeking dissolution of marriage has been filed on 28/5/2013. Accordingly, it was held. Full stop. It was further held that respondent that the appellant has treated the respondent with mental cruelty. Accordingly, the marriage accordingly the petition filed by the respondent seeking dissolution of marriage on the ground of desertion and cruelty has been allowed. In the aforesaid factual background, this appeal has been filed. Learned counsel for the appellant submitted that the family court ought to have appreciated that the respondent has not pleaded any specific instances of cruelty, and the appellant was forced to leave the matrimonial home. It is also urged that mere living separately does not make out a ground for desertion. On the other hand, learned counsel for the respondent has supported the order passed by the family court. Is submitted that appellant, that with the consent of the appellant, petition under section 13B of the Hindu Marriage Act was filed on 16/12/2010. The appellant had agreed for dissolution of marriage subject to permanent alimony, subject to payment of permanent alimony of ₹5 lakhs. However, subsequently the appellant did not appear before the family court, as a result of which the petition was dismissed on 7/1/2012. It is urged that the order passed by the judgment passed by the family court is based on meticulous appreciation of evidence on record and does not call for any interference in this appeal. We have considered the submission made by learned counsel for the parties and have perused the record. It is well settled in law that in a petition seeking decree of divorce on the ground of cruelty, specific instances of cruelty have to be pleaded. C. Neelam Kumar versus Jaya Rani, 2010, 13 SCC 298. Full stop. It is equally well settled. Full stop. Then write a constitutional bench. A 5-judge bench of Supreme Court is urged. the backdrop of aforesaid well-settled legal propositions, the averments made in the petition may be seen. Full stop. From perusal or the averments made in the petition, it is evident that specific instance that no instances of cruelty have been pleaded, except for saying that respondent has treated the appellant with mental cruelty. Full stop. The aforesaid averment is vague and the averments made in the petition do not disclose any specific instances of cruelty. Full stop. The family court, however, without appreciating the opposite aspect of the matter in a casual and cavalier manner, has granted a decree for divorce on the ground of cruelty. Paragraph. Similarly, even though paragraph, we have carefully scanned the evidence. We have carefully gone through the evidence of the appellant. Wherein she has stated that she is living away from the respondent since 15/11/2010. However, the evidence of the appellant does not disclose that she has intentionally abandoned the matrimonial home without a reasonable cause. The appellant has miserably failed to prove. The respondent has miserably failed to prove the intention on the part of the appellant to bring the cohabitation to a permanent end. Full stop. There is no animus desidendi on the part of the appellant. Full stop. In the absence of desidendi on the so and so, therefore, the family court could not have granted a decree of divorce on the ground of desertion. Paragraph 40 aforementioned. The judgment and decree passed by the family court cannot be maintained in the eye of law. It is accordingly quashed and set aside. The petition filed by the respondent under section 13 of the Act is dismissed. The result appeal is allowed. But 32.
Serial number 34. Serial number
33, 34. Ulal and senior counsel captain. Right name, learned additional government advocate, learned senior counsel for the appellant prays for accommodation on the ground that the issue pertaining to amendment in the Karnataka Land Reforms Act 1961 is pending adjudication before the Supreme Court. In view of a court submission, hearing is deferred by 3 weeks. 3 weeks. 35.
Serial number 35. In the first matter, I am appearing, my lord. It appears that both appeal might be infructuous for the reason that, my lord, these appeals are filed against the interim order. My lord, in the first case, I am appearing for the appellant.
A counsel for the appellant. Fairly, both of which.
Reserving liberty to the appellants to prosecute the writ petition, my lord, contest the writ petition. What happened, my lord, on 22/6/2017, learned single judge granted interim stay, my lord. Against that order, these appeals have been filed. Subsequently, in the writ petition, my lord, on 15/12/2017, learned single judge has passed order permitting the respondent 1 to 3 reporting for duty. Thereby, the interim order has been complied. Now, the question is on merits, writ petition has to be decided after taking note of contention of both the parties.
That will be decided, right? Madam, interim order does not adjudicate the rights of the parties, right? Fine. Right. This intra-court appeal has been filed, item number 35, 4398 bar 2017. This intra-court appeal has been filed against order dated 20th/6/2017. Interim order dated 20th/6/2017, passed by learned single judge in the writ petition, paragraph. It is not in dispute that subsequently learned single judge has passed an order on 15/12/2017. 15/12/2017, by which what has been done?
The respondent 1 to 3, who are the petitioner, have been permitted to.
By which respondents 1 to 3 have been permitted to join
report for duty. Report for duty.
report for duties. Full stop. Paragraph in view of opposite subsequent order, comma. We are not inclined to examine the validity of the order dated 20th/6/2017, passed by learned single judge. Needless to state that an interim order is passed only for the purposes of adjudicating the prayer for interim relief made in the petition, and rights of the parties are not adjudicated while deciding the same. The rights of the parties have to be adjudicated in the writ petition, which is pending adjudication. With the aforesaid,
We may be permitted to contest the writ petition.
with the aforesaid liberty clarification, the appeal is with the aforesaid clarification and keeping all the contentions open to learned, open to parties, including the issue with regard to maintainability of the petition, comma, the appeal is disposed of. Same order.
Much obliged.
Can we run? We thought that you are telling us it, that memo telling us it has become infructuous. Yes. After ready. Why not? You are equally experienced, Mr. What is there? Nothing. See, Mr. Very often our experience is most complicated problems have a very simple legal solutions, which do not require any expertise, right? You know the law. No senior counsel. You will become senior counsel only by arguing, right? What is it? Her direct is not to stop vehicle carrying building material on the plot. First read appeal means what? 4594. What is it? Oh, you relax first, relax. We'll take, relax. So what? Yes, Mr. Which case? 4594, 595. Which case you are addressing? But that's what he's saying, no order. 45. 99. Or to hold inquiry. No other provision in the act. No other provision. May have, but no other provision in the act. Ah. So how much land you have been granted? How much land have you been granted? There is notification 20 to 8. Yes.
Notification. Notification. That very notice of issue, draft notification.
What is it that to show that it's a revenue land and not included in the reserve forest or forest?
AFO. AFO is the member setup. It can always.
This notification has come subsequent. The order was passed by learned single judge on 16 June 2017. Thereafter, this notification has been published 22nd August. And DFO is member secretary, right? This monitoring committee. That's correct.
The subsequent jurisdiction is there, is not answered. That is now superseded by the notification. This committee, they themselves are saying that let them take, if they want to let them take.
Subsequent event, right? Ah. So, Mr. Oh, what happens to these notices? Monitoring committee is a different thing, right? Under its purview of inquiry is also different. What I mean. That's correct, Mr. What happens to the subsequent? You will have to take a stand, right? This notification has come subsequent to the order passed by learned single judge. What is the impact? His contention is that now the controversy would be governed by this notification once it has been declared a eco-sensitive zone. And if he is carrying out any activity which is not permissible in eco-sensitive zone, who is the authority which can take action? Monitoring committee.
Not under the.
Yes.
Those are the general powers, as far as forest office.
Yes.
The activities are regulated or be carried out.
So we'll permit them to this monitoring committee. Oh, of course. No. Yes. Correct. Common order. 2 appeals, common order. Huh? $36, right? 36. 36 and 36.1. These intra-court appeals rise out of a common order dated 16th of June 2017, passed by learned single judge in WP number 52947/2016 and WP number 53175/2016, by which the petitions filed by the appellants have been dismissed and the notice dated 18/7/2016 issued by who had issued the notice? Issued by Chief Conservator of Forests.
Yes.
Chief Conservator and validity. What is it? And validity of the issued by has been upheld. Facts giving rise to filing of these appeals briefly stated are that appellant is you are a trust. That the appellant number 1 appellant number 1 is a trust trust which has been constituted with an object to what? Which has been constituted with an object to impart education. Full stop. The that's giving rise to filing of this appeal briefly stated are that appellant number 1 in WA 4595/2017 is a trust registered with an object to impart education. Impart in constitute with an object to impart free education on the ancient Gurukula system of best education, right? The appellant number 1 is the owner of land bearing survey number 227, measuring 60 acres and 13 guntas, situate at village Bomsandra House. Bomsandra, what? Which place? Kanakpura Taluk, Ramnagar district, right? Full stop. Between a period from 29/10/1997 till 13/5/1992, the trust has obtained the permission to convert the lands in question. It is the contention of the appellants that appellants that the land in question is a revenue land situate in what you said? What you said, periphery?
Enclosure.
Enclosure village situate adjacent to what? Enclosure village situate adjacent to Kaveri Wildlife Sanctuary. Full stop. Paragraph. The Chief Conservator of Forest. The Chief Conservator of Forest issued a notice dated 18/7/2016 to the appellants by which an inquiry under section 99 of the Karnataka Forest Act 1963 was sought to be initiated. Full stop. The appellants challenge the validity of the aforesaid notices. You said thereafter similar notice was issued. No. Validity of what have you written? First aspect. Put that. The appellants, notices dated 18/7/2016 to the appellants. The appellants challenge the validity of the aforesaid notices in 2 writ petitions, namely WP number 52947 bar 2016 and WP number 53175 bar 2016, inter alia, on the ground that the which writ petition?
53175.
Delete.
Notice is changed.
The appellant challenge the validity of the notice in WP number 531, not to notice, to writ petition. Delete notices to so and so. The appellant challenge the validity of the aforesaid notice in a writ petition, namely WP number 53175 bar 2016, and in the other writ petition, namely WP 52947 bar 2016, the appellant sought a writ of mandamus to direct the respondent not to stop the vehicles carrying material or any other vehicle to the plot of the petitioner in that petition. Full stop. Paragraph. The aforesaid petitions were heard analogously by learned single judge and have full stop. Learned single judge by a common order dated 16th of June 2017. inter area held that the notice issued to the appellant in WA 4595/2017 does not suffer from any infirmity. The appellants have been granted the liberty to avail the appropriate remedy at the relevant stage. Accordingly, the petition has been dismissed. In the aforesaid factual background, this appeal has been filed. Paragraph. These appeals have been filed. Paragraph. Learned senior counsel for the appellant submitted that subsequent to passing of subsequent to the order passed by the learned single judge, that is on learned senior counsel for the appellant pointed out that the order was the learned single judge dismissing the writ petition preferred by the appellants on 16/6/2017. Thereafter, the Ministry of Environment, Forest and Climate Exchange, Government of India, in exercise of powers under Section 3 of the Environment Protection Act, has issued a notification dated 22nd August 2017, by which the village Bomsandra, where the lands of the appellants are situated, has been declared to be an eco-sensitive zone. It is further submitted that under clause 5 of the opposite notification, central government has constituted a monitoring committee which has the authority to monitor the activities in an eco-sensitive zone. It is therefore urged that on account of aforesaid subsequent event, the notice dated 18/7/2016 be quashed, and the monitoring committee constituted under the notification be granted the liberty to take action in case it is found that appellant is carrying out any activity in contravention of the notification dated 22nd August 2017. Paragraph. The aforesaid prayer has not been fairly opposed by learned additional government advocate. Paragraph. We have considered the submissions made on both sides. Full stop. Admittedly, after the order was passed by the learned single judge on 16th of June 2017, by a notification issued by Ministry of Environment, Forest and Climate Exchange, Government of India, in exercise of powers under Section 3 within bracket 3 of the Environment Protection Act, the village in question, namely Bomsandra, has been declared an eco-sensitive zone. Full stop. The clause 4 of the aforesaid notification provides the list of activities which are prohibited or to be regulated within the eco-sensitive zone. Full stop. Clause 5 deals with constitution of the monitoring committee, in which representatives of Government of Karnataka, namely representatives of various departments of Government of Karnataka, namely Department of Environment, Department of Urban Development, Karnataka State Pollution Control Board, State Biodiversity Board, the Deputy Conservator of Forests are the members of the aforesaid committee. Full stop. The aforesaid committee under the notification has the authority to prohibit or to regulate the activities within the eco-sensitive zone. Full stop. The appellant is bound to carry out the activity only in terms of the notification which has been provided. Paragraph. In view of aforesaid subsequent development, notice dated 18/7/2016 issued by issued by Chief Conservator of Forest is hereby quashed. However, liberty is reserved to the monitoring committee. However, the monitoring committee shall ensure that the appellants carry out the activity in the eco-sensitive zone strictly in accordance with para 4, not clause 4, right? Para 4 of the notification. Right, with the para 4 of the notification, with the aforesaid direction, the writ petitions, the appeals are paragraph for the aforementioned reasons in view of aforesaid subsequent development, paragraph for the aforementioned reasons, order dated 16th of delete everything. For the aforementioned reasons, order dated 16th of June 2017, passed by learned single judge in WP number so and so is hereby set aside, and the appeals are disposed of in terms of the aforesaid direction. So you have said no somewhere. Of aforesaid. Where you have said aforesaid subsequent development. No, you say before it is right. It is dated question. Before that, what is? Just one sentence before that. In view of aforesaid subsequent. No. Quashed before quashed notice dated so and so is quashed. No. Before that notification dated 18/7/2016 is quashed. We have written no somewhere, not written.
Or to regulate the activities within the eco-sensitive zone.
To carry out the activity in eco-sensitive zone. Very please ask madam, I won't remember what if you leave like this. You are unable to get it. We have said, we have said somewhere that notification dated after submission, you read after their submissions are recorded. Additional government advocate. Government advocate, not additional. Government advocate.
Senior.
Additional.
Senior.
After senior counsel, government advocate. Thereafter, what paragraph? Hey, Mr. Nataraj, you should have told us in the beginning. I would have kept it in the chamber. Yes, madam. So what is it after submission?
Issued by excess of powers under section.
Admittedly, after this thing, learned single judge passed an order dated so and so, Government of India, read
Section
3(3) of Environment Protection Act 1986.
Eco-sensitive zone.
Issued a notification. By which village in question has been declared to be an eco-sensitive. Yes.
Activities which are prohibited
para 5, full stop, para 5. Constitution of monitoring committee of representatives of
Forest Department, Government of Karnataka,
or representative of various departments of government of Karnataka, namely Department of Forest, etc., whatever. You should have told us, madam, that you have difficulty. I won't get it.
or to rectify it's within the eco-sensitive zone.
Ah.
The bound to carry.
Ah.
Only in terms of the notification which has been provided.
Then
Of the aforesaid subsequent development. Dated
no, in view of, now you write in view of aforesaid subsequent development, it is not necessary. In view of aforesaid subsequent development, comma the, the chief conservator of forest cannot continue the proceeding under section 99 of the Karnataka Forest Act 1963. Full stop. Full stop. The notification dated 18/7/2016 is therefore quashed, right? And then whatever. Give it in.
Which part? 38. Colleagues, not people.
30, 38. Article 38 lists this petition before a bench in which one of us within bracket honorable, let's right? He is not a member.
Number 39, Ken Puttegoda.
99. It was the 299. Quickly.
Must be compounded.
Here, as
Can you read it, Mr.? You can read, right? There. 3.1. Fine. What? Go ahead. What is? It's a
Here is the most important one. Here, the conception here is part of two is it is revenue area. Therefore, this not they must take place.
under clause 3.1. That's it. Hey, Mr. How it can be? Yeah, 1 minute. Prima facie, the learned single judge seems to say that if your plot is less than 6 meters, it's in width or height, no permission anywhere. Anybody can raise whatever construction he wants. This is something, any construction activity, just a minute. We want to, you will of course hear you. I mean, this is what the order seems to suggest, that it's not regulated by any law. Anybody can do anything. If I have a plot less than 50 meters, I can do whatever I want. No permission, no law applies to me, right? This is the order. Yes. It can't be like this.
The lawmakers.
No, wait. You know, no, you belong to what? EWS.
Next goes, he's with the charter. This is one, all the area is with this area, and finally. Oh man, and he. We're going to hospital. It's an empty print out. Make anything. You know that.
No, you are governed by law. Whatever it. So like whatever. That's all right. What? You are not governed by any law. Labor class means above law. No, this. If it says that no plan shall be sanctioned, it doesn't mean that no plan is required. You are trying to read it. No sanction is required for doing it. This is what you are reading. This is incorrect. And it says in specific cases of sites so and so densely populated, so an authority may relax above condition. That power is there with the authority. So, Mr. What should you do now? He has raised a construction. Can you compound it? Power? Steps. Revenue layout means
This piece is under challenge.
that this much.
That will not.
No, we like this.
320. No, sir.
Karnataka Appellate Tribunal. We don't know what is. What was the notice given by you to him? 321(3). So you are relying on this bylaw. No plan shall be sanctioned means no plan is required. You are also not convinced, right? That's why you are smiling. You are not convinced.
Yeah, area, when you say that. Area.
Wait, don't restrain yourself. You are not doing anything against you. What, you had been asked to demolish the construction? What was the notice issued under 321(3)? What what the notice asks you to demolish? Notice says that you should demolish the building. That's what we are asking. And that against an order was passed under 321(3). You filed an appeal that has been. Yes. So why, how do you say that no permission is required? You know, it's the provision, only 7.2 of the budget. Like this is 30%. Where is the provision of compounding? Compounding. Which under which provision, Mister? We are asking you under which provision? A compounding scheme.
Deviation. Bylaw 6 says deviation. 6.
Which power? So under which provision you say? This is we are dealing with Karnataka Municipal Corporation.
Same.
First of all, Mr. Tell us which provision requires you not to obtain, which provision rather exempts you from requirement of obtaining permission. All right. That's 7.2 does not say so. Yes, all right. What else? Anything else? Latest act means Karnataka Municipal Corporation Act is not, it has been repealed. It has been repealed. Micus. He doesn't seem to listen to us. But what we say matters, right? Because we have to write judgment. He may say anything. But if he doesn't follow us, then he will be in difficulty. Huh? We asked him a question whether Karnataka Municipal Corporation Act has been repealed. He has not answered. Which section? %50 in respect of the building regular. So 50% has to go. Whatever. But not applicable. Hey, we won't direct. Do whatever. Don't say that judges told me to go. We won't. We are not saying anything you are saying. You will write in that application. The judges directed me to go. We are not. We are not direct. This 7.2 does not say what you are saying. Whatever. Everybody is bound. That's it. All
Yes, 12:14. That's
14, 15, 16.
12,
12, 13, 14.
Yes.
Yes, my they will list. Yes. One minute. Synopsis filed by advocate for appellant is returned with the office objection. What office of? Don't know. All right, we'll hear you tomorrow. Sorry, counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same this next week. Next week. No, next week. Oh, right.
This date was-
Or to argue. Take it up. Yes, 47. Why is he seeking adjournment then if you filed it? It will be called tomorrow.